My name is Yogya Bhatia and I am a legal intern at LEXIS and Company. Today we'll be talking about patent laws in India. Similar to trademarks, copyrights, design and geographical indications, patent is also an intellectual property which is protected under the law, and the rightful owner of the patent can claim rights and authorities under the law for a limited period. In India, the law of patent is primarily governed by the Patent Act of 1970. What is a patent? The word patent refers to a monopoly right over an invention. Not all inventions are patentable, nor it is essential to protect inventions solely through patent. The final product that results from an invention may be protected through other forms of intellectual property rights. The statutory definition of patent under the Patent Act as a patent for any invention granted under the Act. The subject of patent law is to encourage scientific research, new technology, and industrial progress. Grant of exclusive privilege to own, use, or sell the method or the product patented for limited period stimulates new inventions of commercial utility. The price of the grant of monopoly is the disclosure of the invention at the patent office, which after the expiry of the fixed period of the monopoly passes into the public domain. What are the rights of a patent? Patent registrations confers on the rightful owner a right capable of protection under the Act. That is, the right to exclude others from using the invention for a limited period of time. The monopoly over patented rights can be exercised by the owner for a period of 20 years, after which it is open to exploitation by others. Patent confers the right to manufacture, use, offer for sale, sell, or import the invention for the prescribed period. What is the time period for which patent is granted? Initially, the Act provided for a short term of protection for medicine or drug substances. However, the Amendment Act of 2005 uniform period of 20 years was provided for all the patents. Thus, once the prescribed period of 20 years is over, then any person can exploit the patent invention. Here, it would be relevant to mention that similar to trademark, even the term of patent begins from the date of application of patent. What are the requirements for grant of patent? The application for patent shall be made at the Indian Patent Office. Any person, that is, Indian or a foreigner, individual, company, or the government can file a patent application. The person applying for a patent shall be the true and first inventor of the invention proposed to be patented. The patent application can also be made jointly. The patent application shall primarily disclose the best method of performing the invention known to the application for which he is entitled to claim protection. The application shall also define the scope of invention. A patent application can be made for a single invention only. The Act under Section 2, Subsection 1 defines invention as a new product or process involving an inventive step capable of industrial application. The term industrial application means that the invention is capable of being made or used in an industry. One of the prerequisites of an invention is that it should be new, that is, the invention proposed to be patented has not been in the public domain or that it does not form part of the state of the art. Under the Patent Act, both processes and products are entitled to qualify as inventions if they are new, involve in an inventive step, and are capable of industrial application. Requirements to qualify as invention. The invention must be new. Invention must involve an inventive step. The invention must be capable of industrial application or utility. The invention shouldn't come under the inventions which are not patentable under Section 3 and 4 of the Patent Act 1970. What inventions are not patentable? Non-patentable inventions are enumerated under Section 3 and 4 of the Patent Act. Any invention which is frivolous or which claims anything obviously contrary to well-established natural laws is not patentable. Any idea or discovery cannot be subject matter of a patent application. Inventions pertaining to known substances and known processes are not patentable. That is, mere discovery of a new form of a known substance which does not enhance the known efficacy of the substance is not patentable. An invention obtained through arrangement is not patentable. A method of agriculture or horticulture cannot be subject matter of a patent. Any scheme or rule, presentation of information, topography or integrated circuits, Traditional knowledge. Inventions relating to atomic energy are not patentable. Infringement of a patent. Infringement of a patent primarily refers to intrusion or violation of the rights of a patentee against which patentee has statutory rights under the Act. While determining the infringement, it has to be assessed whether the infringement activity fell within the scope of the invention. Thus, the infringement has to be determined with regard what has been claimed as invention under the Patent Act. To determine the infringer, that is the person liable for the infringement, to determine the infringing act fell within the act which do not amount to infringement under Patent Act's excluded acts of government use of a patented product or process of experiment or research, import of medicine or drug by government and patent in foreign vessels and aircrafts.